Deutsche Trustee Company Limited and Justice Flaux, BD and others.
Good morning, my lords and my lady. I appear with Mr. Goldring for the Appellant Collateral Manager, Barings. Mr. Wolfson and Mr. de Mestre appear for the third and principal respondent, Napier Park, which also acts as representative of the Class F Noteholders. And Mr. Robbins appears for the first respondent, the trustee of the issue, Deutsche Trustee Company, which as Part 8 claimant brought this matter before the court, but which takes no active part in the substantive argument. My lord, my lady, I should add that there's no appearance today by the second respondent, the issuer, Duchess 6 CLO BV, but it is confirmed by its solicitors, Baker Mackenzie, that it does not intend to take an active role in the appeal, and as would be expected, is content to be bound by the decision of this court. My lords, my lady, the appeal is by my client's Barings from the judgment of the Chancellor dated the 28th of March last year, whereby he answered 5 issues which had been posed to him by the parties as to the construction of the Collateral Management Agreement, which was entered into Barings in connection with the Duchess 6 CLO securitisation. And the issues addressed by the Chancellor were those set out in the annex to his judgment. And
can I just say, Mr. We've all read the judgment below very carefully. We've read the skeleton arguments. Some of us have also read all the witness statements. So we are really very familiar with what the issues are. And I think we're very familiar with what all the arguments are. So you don't really need to go through any of that. It's a point of construction. It's an important point of construction for all the parties involved. But for our part, I think we would prefer you just to go straight to the arguments on the construction issues.
Certainly.
And may I also say this is one of those cases where, because everything has been so very well, if I may say so, set out in the skeleton arguments as well as in the judgment below, I'm not sure how profitable it is for everybody to address every single one of those arguments all over again, repeating what's in the skeleton arguments. And for our part, it's a matter for you and the other advocates here, for our part I think we would prefer you all to concentrate on what you think are the most important issues, whether strength of your side or weakness of the other, rather than going through every single argument again. It's a matter for you.
well, certainly, my lord, I will endeavour to follow that. But perhaps what I could do then, just at the start, is to outline the order in which I'm proposing to take the substantive issues. And what I propose to start with is just to touch very briefly on the law. I don't need to do that more than very briefly. And then to introduce various aspects of the transaction relevant to the issues. And my lord, my ladies, that's simply because there are certain points in going through some of the documents which I will be picking up later and which it will be useful to flag before I come to the substantive issues. What I then propose to do is to address the issues considered by the Chancellor broadly in the same issue as he adopted, and to do so under 6 headings. The first is clause 14.1 of the Collateral Management Agreement, or the CMA. The second is the definition of the Incentive Collateral Management Fee, or the ICMF. And both of those first 2 headings relate directly to issue A. The third is the definition of cumulative subordinated income, or CSI, which relates to issue D as well as to issue A. The fourth is the definition of secured income threshold, or SIT, which relates to issue C as well as to issue A. The fifth is a separate point relating to the redemption threshold amount, or the RTA, under condition 7B, which goes to issue A. And the last and sixth is the accrued and unpaid wording in condition 11, which goes to issue B as well as to issue A. So my lords, my lady, with that overall route map, perhaps I could just begin by touching briefly on the principles of construction, which are of course well known to this court. They are not in dispute, and the relevant cases which encapsulate the modern approach were referred to by the Chancellor, in paragraphs 28 to 31 of his judgment, and are before you in the authorities bundle with the relevant and familiar passages marked. My lords, my lady, in those circumstances, there are only two comments I would make about the Chancellor's summary. First, in paragraph 30 of his judgment, he correctly referred to the iterative process of checking rival meanings against other provisions and investigating their commercial consequences. But that doesn't, in our submission, do full justice to the nature of the unitary exercise endorsed by the Supreme Court, or indeed identify what the court should do once it's looked at the commercial consequences. And the answer to that is, in fact, uncontroversial in our submission in the authorities, and is to be found in Rainy Sky, and in particular Lord Clark's judgment at paragraph 30. And if I could ask my lords and my lady just to briefly look at that. It's in tab 3 of the authorities bundle. And it's paragraph 30 where Lord Clark, having referred to Lord Justice Longmore's judgment in Barclays and HHY Luxembourg, endorses Lord Justice Longmore's approach. And just below letter E says, where a term for contract is open to more than one interpretation, it's generally appropriate to adopt the interpretation which is most consistent with business common sense. My lords, my lady, in our submission, it's important to keep that in mind when considering the rival meanings advanced by the parties. And secondly, in paragraph 31 of the Chancellor's judgment, the Chancellor correctly referred to Lord Collins's speech in Sigma, where Lord Collins rightly observed that the factual background had a comparatively limited role in the context of traded instruments. Now, that's not in dispute, but it doesn't, in our submission, fully capture the point that Lord Collins was actually making. And one sees that from his speech in Authorities Bundle 2, starting at paragraph 35, tab 2 of the Authorities Bundle, page 589 of the internal report, where he says, picking it up just above letter D, in complex documents of the kind in issue, there are bound to be ambiguities, infelicities, and inconsistencies. An over-literal interpretation of one provision without regard to the whole may distort or frustrate the commercial purpose. This is one of those too frequent cases where a document has been subjected to the type of textual analysis more appropriate to the interpretation of tax legislation, which has been the subject of detailed scrutiny at all committee stages, than to an instrument securing commercial obligations. In other words, Lord Collins is cautioning against over-literal interpretation of documents such as this. And he picks the point up in paragraph 37, after the sentence quoted by the Chancellor, which starts just above letter J at the bottom of the page. The one referring to the instrument must be interpreted as a whole in the light of the commercial intention, which may be inferred from the face of the instrument and from the nature of the debtor's business. Lord Collins then continued by saying, detailed semantic analysis must give way to business common sense. And my lords, my lady, the Chancellor's approach, as you have seen from his judgment, was to conduct a textual and literal analysis of the relevant provisions of the documentation, and then, having formed what he considered to be a clear view of their meaning, to consider whether commercial factors provided or pointed towards a different interpretation. Now, we would suggest that the right approach, when engaged in the unitary and iterative process, is not just to look at commercial considerations when standing back at the end of the overall textual analysis, but also to consider them as they arise during the textual analysis, so that they can better inform the meaning of the language of the relevant phrases and expressions used. And that is what we will be seeking to do in our submissions. And my lords, my lady, that is all I was proposing to say in relation to the law, but by way of introduction to the transaction and the documents and some of the wider commercial aspects, it's probably convenient first just to show my lords and my lady certain parts of the prospectus in bundle B1. This is a 275-page document and one of the 18 formal documents or agreements produced as part of the issue.
Can I just ask this question about the documentation? There's no evidence, as far as I could see, about this point, but are there many other instruments or transactions which have identical wording to this, which are still current? Identical wording.
I think the answer is that there is similar wording in the Duchess 7 CLO, which has, I think, very recently matured. But I will take further instructions, seek further information in relation to that. And I think it was certainly understood by the Chancellor that there was a possibility of similar wording being engaged in the Duchess run of CLOs. To what extent it is used in other CLOs, I'm afraid I'm not in a position to help your Lordship.
So this case wasn't on the face of it a trailblazer for a whole load of others, as cases in the financial list sometimes are.
I think that's right. It may be a trailblazer for the Duchess.
Maybe a
run.
trailblazer for one other.
Yes, but it doesn't, at the moment, subject of course to instructions, appear to be wider than that.
Before I forget the point, because your eloquence is taking us along quite swiftly, just a slight note of a discord at the beginning, if I can register this with whoever's responsible. Just to say that your notice of appeal does not comply with the requirements and regulations and the authorities, because it contains argument in it. I try to make this point when I can to people. A skeleton argument, it's quite clear from the notes and guidance, should only contain, in very few terms, the grounds of appeal. I'm not going to weigh on this too much, but when I see this happening, I do mention it so that everybody can hear and learn for next time. That's all.
By the way, I'm sorry about that transgression in this case, but duly noted.
Thank you. Go carry.
My lords, my lady, in relation to the prospectus, I think I can take this very rapidly, given what my lord, the Master of the Rolls, said at the start of this hearing. But one sees on page 9 the structure of the transaction, with the issuer being identified, as one would expect, as a sole purpose vehicle. Its purpose being to acquire the portfolio. And as I hope you will have seen from the evidence, the portfolio consists primarily of collateral debt securities, mainly high-yield loans, and which comprised usually some 100 or so different securities. And one sees in the table halfway down the page that the notes being issued were divided into 7 classes. Classes A to E are the rated debt notes, with increasing interest rates, as one sees in the interest rate column, reflecting the increasing risk. And Class F is the equity tranche, in other words, the highest risk at the end. And you will see that it says NA in respect of the interest rate.
So is this internal line, or is this...
My lord, I'm sorry, it's B1, page 9.
it's at the bottom right-hand corner.
Yes. I'm sorry, my lord. And I was referring to the table at the bottom of the page,
Oh, I see, yes, I see.
identifying the different classes of notes. And if one looks at the line, some 3/4 of the way down, for the Class F secured income notes, one sees not only the principal sum of €52.5 million, but under the interest rate column, an NA is inserted, with a footnote saying subject to the provisions of interest 6, condition 6. And there are, in fact, various elements of interest that are payable to Class F under the conditions, as I will show my lords and my lady in due course. Now, Class J, which appears underneath Class F, is a combination of Class E and F, but is effectively irrelevant for present purposes, and I think its common ground can be ignored. over the page one sees that the notes, as to be expected, were to be issued pursuant to a trust deed. And at page 13, the Collateral Manager is introduced, as is the Collateral Management Agreement. And we'll see the function and indeed the fees payable in more detail from the Collateral Management Agreement in a moment. But it's summarised here. And in essence, the Collateral Manager is responsible for the selection, management and sale of the collateral.
Where are you reading from now?
My Lord, it's a paragraph in the middle of the page.
Page 10.
Page 13. I am so sorry, perhaps I'm trying to take this too rapidly.
That's fine.
It's the middle of the page,
Exactly.
the paragraph in the left margin referring to the Collateral Manager.
Yes.
And simply identifying here in summary form the Collateral Manager's responsibilities for selection, management and sale of the debt securities comprising the portfolio. And as is obvious, and indeed agreed in the Statement of Agreed Facts, paragraphs 13 and 19, the performance of the issuer and the returns to the Class F equity notes will necessarily be dependent on the skills of the Collateral Manager. And if I could invite my lords and my lady to go forward to page 211, as I don't think, given the pre-reading that the court has done, it's necessary to look at other parts of the prospectus. But at page 211, there is a section headed Description of the Collateral Management Agreement. And this introduces the fees payable to the Collateral Manager. One sees in the very top third or top quarter of the page as being first the base collateral management fee, which is payable in arrears, and secondly, a performance-related fee, the Incentive Collateral Management Fee. And my lords and my lady, it would, as a generality, we would suggest, it might be expected that a performance-related fee would relate to the performance of the portfolio over the life of the issue until maturity or redemption, and wouldn't depend on what brings about the redemption, or wouldn't be not payable if there's an optional redemption by the equity note holders. And on the evidence before...
Mr. Elton?
I'm sorry, ma'am.
Why does that follow necessarily?
Well, just as a general expectation, it's not necessarily the position, and I don't suggest that is. Of course the parties could agree something else. But just as a generality, a performance fee based on the performance of the notes.
If it doesn't necessarily follow, then the issue for us is what was actually agreed.
Indeed. But when one, as we will be seeing in various parts of the detailed definition, when one's looking at the definitions and questions that arise in respect of that, it is in our submission quite important just to have in mind what the general nature of the fee is.
And your submission goes no further than this is a performance fee. That's it.
Indeed, indeed. Although it goes slightly further in this sense, in that on the evidence before the Chancellor, the view or the suggestion that I just put forward as to what performance means in this context appeared to be a widely held view in the market at the time the Class F Noteholders voted for optional redemption. Now, of course, I fully accept that this material has only limited relevance on the issues of construction, but perhaps I might just very briefly show the court that material before making submissions as to why it is of some relevance.
Right.
And one sees it from Mr. Faulkner's first witness statement, which is in Bundle C, tab 2, at page 30. And taking first paragraph 43, and Mr. Faulkner's reference to the model for the transaction by Intex Solutions, Inc. Intex being a firm that models CLO and trans...
What paragraph, Mr.
It's paragraph 43, Bundle C, page 30. And it's a reference in the first line of paragraph 43 to the model produced for the transaction by Intex Solutions. Intex being a firm that models CLO transactions and provides a reference service for the industry, indeed has done from the early 2000s, providing information used by market participants to form views on the value of the notes and hence the price in the secondary market, where Napier and various other Class F noteholders acquired their notes. Now, it doesn't, of course, mean that they are right on the legal construction of the documentation, and we don't refer to their analysis for that. But we do refer to it as a check on the commerciality of our construction, and indeed in support of a commercial expectation that a performance-related fee dependent on the internal rate of return to the Class F noteholders would be paid by reference to the performance of the notes and the returns to those noteholders.
But we have no evidence about the instructions that were given to Intex Solutions when producing this model.
That's correct, my lady, but what we do know is that they will analyse the documentation. The documentation, these are traded notes, the documentation is available, it's on what people make their judgments, and what they do is they analyse them, analyse the cash flows, and provide a publicly available library for each CLO. Now, Intex's model, as one sees from paragraph 43, identified approximately 15 million euros as being payable on an optional redemption in May 2018, essentially the same as Barings' calculation, and what is agreed to be payable if an incentive fee is payable at all. And this was a view shared by Napier Park at the time. If one goes back to paragraph 39 of Mr. Faulkner's witness statement, at the top of page 29, one sees that Mr. Faulkner refers to messages exchanged between him and a Miss Julia He of Napier Park. Julia He being a managing director at Napier Park Global Capital, and she was estimating in January 2018 a 15 million euro incentive fee being payable on an optional redemption. Now, that's been explained by Mr. Micco in his evidence that Miss He sent that in reliance on the Intex model. There's no reason to doubt that, but it does show the relevance and importance of the model in the market, and again, the expectation that a performance-related incentive fee relates to the overall performance of the issue. Now, my lords and my lady, while on high-level commercial issues, I should address the evidence from Napier, which was considered by the judge at some length. It's set out in paragraph 26 of the judgment and then picked up by him in paragraph 48. And this was evidence as to how the financial crisis derailed the issue, and that it is possible that if the crisis hadn't intervened, the notes might have performed differently, and there might have been no optional redemption either in 2018 or at all. And so even on Napier's construction, an ICMF could have been payable. Now, it's of course possible to envisage circumstances where the events which Napier contend deprive Barings of the ability to earn an incentive fee do not occur. But what will happen over the life of the notes is necessarily unknown when the transaction is entered into. And all that can be said is that it is an obvious possibility that the issue might end on an optional redemption at any time after 5 years, as that is what the documents provide for. And that is irrespective of how well, comparatively or otherwise, the issue does. And indeed, the evidence before the Chancellor shows that this issue was in the top 20% of the 2006 CLOs. But my lords, my lady, positing circumstances where Barings might have got something on Napier's construction shows only that that construction doesn't necessarily deprive us of any incentive fee, but it simply doesn't address the question of whether one is payable if the option to redeem is exercised. My lords, my lady, the next document to show you is the trustee which constituted the notes. And that is at bundle B2, comprises the whole.
Right, just to make sure I fully understood that last point. You're saying the exercise of the option to redeem, as it's been exercised in this case, the way it has been exercised, deprives you of the management fee.
Yes.
What has that got to do with the earlier performance? You're relating it back to the performance in times of difficulty. There's a lot of evidence about what had taken place in order to boost up the security, the diversion of interest to superior note holders. There was a lot of evidence about all of that.
Indeed.
But I mean, I'm not sure this last point really depends on any of that, does it?
Well, my lord, it depends on it in this sense, in that what the Chancellor did at some length, by way of some support for the conclusions that he reached, was to say, well, the one thing that wasn't envisaged here was the financial crisis. And if the financial crisis hadn't intervened, history may have been different, and there may have been an ICMF. So what Barings can't really do now is turn around and complain that they don't have an ICMF because of, if you like, supervening factors. And the short point that we make, which we would suggest chimes with points that my lord made to me earlier, is that you can, of course, envisage factual scenarios where history would be different, where an ICMF could have been payable, even on Mr. Wolfson's construction of the various provisions. But the task of this court is to look at the position when the notes are entered into. There are obviously a range of possibilities as to when interest would be paid, as to when principal would be paid on the Class F notes. And what one needs to do, we would suggest, is divorce it from the points that the Chancellor considered to be important, relating to how matters had played out because of the financial crisis. It's that shorter point, and I'm sorry if I made it sound a different or more complicated one.
I mean, basically, saying you look at what's commercially envisaged and commercially realistic at the time the instrument was entered into. Is that the point?
Yeah, indeed. And one construes it, again, bearing in mind what Lord Collins said, one construes it on the basis of the documents and the factual matrix at that time.
Okay, thank you. Yes, trustee.
No, the trust. It's a bundle B2, comprising the whole of the bundle. It starts at page 276. It's a White and Case document, White and Case being the trustees' solicitors. It will be necessary to come back to some of these provisions in more detail when addressing the individual headings. But at this stage, could I just show you the shape of the document and pull out one or two points that in our submission is important. Starting very briefly on page 279, at clause 1A, the master definitions and framework provisions schedule is expressly incorporated. The notes are constituted by clause 2 on the next page. And if one goes forward to page 283, one sees the covenant to pay under clause 3, and that's a covenant by the trustee to pay the note holders on redemption.
Sorry,
Clause 3 on page 283.
You make this point, I'm just trying to make sure we don't overlook anything we're not emphasising. You say the master definitions of framework provisions schedule is incorporated. Would you expect that? I mean, is there a particular point on that?
No, what I was just showing you as a part of the, not adding anything to that. Similarly, in relation, you would expect the covenant to pay that you see in clause 3. Perhaps I could go forward to clause 7, which introduces and makes binding the conditions. That's at page 293, and the conditions themselves start at page 317. being the second schedule to the trust deed. And what you have at the start of the terms and conditions is a list that begins with the first agreement at the bottom of the page, but it goes over to page 319 of all the other agreements that are entered into at the same time. The relevant conditions start several pages on at page 366. Which is condition 3, headed status. And perhaps I could just ask my lords and my lady, I'm conscious that various extracts from these have been included into the core bundle. And I don't know if you've been following this by reference in your notes to the core bundle references or the main document references. I'd be very happy to give both references if it's of greater convenience, but otherwise I was simply going to use the B bundle references.
What do you want us to read?
My lord, clause 3b deals with relationship amongst the classes, and one sees in the second sentence there, some 4 lines down, payments of interest and principal of the notes will be made in accordance with the order of priority of payments in this condition 3 or condition 11. And one sees at the bottom of the page the point made good that Class J notes are effectively irrelevant for these purposes. Over the page, at page 367, is condition 3C. And before one comes to 3C1, which is the pre-enforcement interest waterfall, one sees that the clause at the top of the page is identifying which waterfalls effectively apply. And as it says, the collateral administrator shall, on behalf of the issuer, on each payment date, save for any redemption date applicable to the redemption of the notes pursuant to condition 7b, optional redemption, prior to the delivery of an enforcement notice, disperse interest proceeds, principal proceeds, and then the equivalent sterling ones, in accordance with the priorities of payments in paragraphs 1, 2, 5 and 6 below respectively. And one can, for present purposes, stop there, as the other, or the rest of the condition, is dealing with distributions on dates between payment dates. But what one sees from those first lines is that effectively what is carved out of these condition 3 waterfalls is redemption date, optional redemption under condition 7b, and indeed delivery of an enforcement notice. And as we'll see, condition 11 is engaged in relation to that. Now, under subcondition C1, there is then a long list identifying priorities and subordinations, which goes through to page 371. It will be necessary to come to some of these in more detail later, but as you may have seen at page 370, in paragraph II, the waterfall addresses, in language that I'll come back to, payment of the Incentive Collateral Management Fee.
So which condition?
It's II. I'm afraid in the copy it looks fairly indistinct, but it's at the bottom of page 370. An express provision for the payment of Incentive Collateral Management Fee. Now, over the page, starting at page 371, is the application of principal proceeds on payment dates. In other words, the pre-enforcement principal waterfall. And again, there is a long list, but going forward to page 374, one sees a provision for Incentive Collateral Management Fee in sub condition BB at the top of the page, then it's not necessary for present purposes to look at the application of interest proceeds between payment dates or indeed to anything else in condition 3C. As I say, we'll come back to some of the detail of that later. There are also further provisions relating to sterling and asset swap principal proceeds, but those again unnecessary to dwell on for the purposes of the argument today. Condition 6 at page 385 deals with interest, and at this stage it's just to draw your attention to condition 6A2 near the top of page 385, which provides for interest to the Class F secured income notes. And as you will see from that, there are three types of interest payable to them: coupon, deferred, and additional interest. And it will be necessary to look at the additional interest provision in more detail in a little later. Now, condition 7, which starts on page 391, provides for redemption. And this is divided into a number of sub-paragraphs. 7A, as one sees, deals with final redemption, and that is maturity. And there is, at least it's clear, and I don't believe to be in dispute, that on final maturity, the condition 3 waterfalls that we've just looked at briefly apply. And it is not in dispute that an incentive fee is payable if the thresholds, of course, are otherwise met. Then one comes in condition 7B to optional redemption, and there are a number of different forms of optional redemption. Condition 7B1A, redemption at the option of the Class F secured income note holders, is what occurred here. And one sees in the middle of that first paragraph that it's an option to the note holders on any payment date falling on or after the 5th anniversary of the closing date. In other words, post-August 2011. Now, going over the page, at the top of page 392, subcondition B provides an optional redemption for tax reasons. And one sees in the middle of that paragraph, it requires the consent of the holders of at least 66 2/3% of the aggregate principal amount of the Class F secured income notes. Condition or subcondition C is actually slightly different because it's redemption at the option of the collateral manager. And as one sees just from the first two lines, principal here, if the option is exercised, is paid in accordance with condition 3. In other words, it's slightly different from the other optional redemption provisions, not just because it's the option of the collateral manager as opposed to the Class F note holders, but also because it clearly engages condition 3. Subcondition D at the bottom of the page is a currency redemption. Now, it's again at the option of the collateral manager, save that one sees halfway down that in relation to the Class F note holders, it's at their option. So again, if my lord looks down, in fact, just taking the relevant wording, subject to the provisions of clause of condition 7B2, the notes of each class then outstanding shall be redeemed by the issuer, in whole but not in part, on direction of the collateral manager, and then it's a part in brackets, save for the Class F secured income notes, which shall, at the option of such note holders, be redeemed in whole or in part.
What are we getting out of all this?
My lord, it's showing you the structure because the Chancellor's conclusion was that the incentive fee is payable effectively when the condition 3 waterfall is engaged. As one sees it is in 7A, I'm going to show you that it is in relation to mandatory redemption. He says that in relation to optional redemption, because of the way in which the deed is structured and the various different definitions fall into place later, there is in fact a different position in relation to optional redemption because of it being diverted to condition 11. And what I'm showing you at this stage is the circumstances in which, different circumstances in which optional redemption arise, and which also, in our submission, are to be looked at in connection with the mandatory redemption provisions.
What one could say is that the drafter has been very particular about when condition 7B applies and when condition 3 applies in relation to these various options.
Indeed.
Because, plainly in relation to 7A, we've got a reference there to condition 7A, and then we've got a reference in B1A to condition 7B2, and over the page under C, for example, is a reference to condition 3C2.
Indeed. Indeed, my lord.
So it looks as though the drafters have been very particular about that.
Oh, indeed. Indeed. But my lord, this is a question of the structure as to which conditions apply when options are engaged or redemption, final or mandatory redemption occurs. The second level of the argument, which I'll be addressing under the 6 individual headings, is what is the consequences of that for the incentive fee?
Broad terms, trying to simplify it, but incorrectly, but if we're looking at optional redemption at the option of the Class F securitisation after 5 years, that is subject to the provisions of condition 7B2, and 7B2 makes it clear that the waterfall which operates is the condition 11 waterfall.
Indeed, absolutely.
Whereas when it is at the option of the collateral manager, it's clear that what operates is a condition 3 waterfall.
Indeed, indeed, absolutely.
So one doesn't get any more out of it in one sense than that.
Well, what one does get out of it.
Different optional redemption is handled in different ways.
Yes, that's absolutely right. And I think I can take 7B2 at the bottom of the page.
What we might be more revealing, be more interesting in a way, would be why, for example, under what is the reason, the commercial reason, why under 7C, the redemption at the option of the collateral manager engages condition 3C2 there, whereas in relation to, for example, D, which is also the option of the collateral manager, it's 7B2. One have to look at it very carefully. You studied this, no doubt, and those behind you, for weeks and months on end. But what is the reason for that? What is the commercial reason for that distinction?
Well, my lord, I'm not sure that we have that anywhere in the evidence as to why that's done. Because, of course, our focus is much more on the commercial reason for a distinction in respect of the payment of the incentive fee. And at the moment,
I appreciate that, but the only point I'm picking up is that you're showing us these different ways in which this all operates, and what we've seen and what you've accepted is that the draft has been quite careful in seeing which is the condition that's engaged for calculating the payment of what's due, it's an obvious point, which is to say, well, you've got two situations here where the redemption is the option of the collateral manager, and they're opting for different provisions which govern it. Why would that be? Because that might throw some light on perhaps some of the points you're making. I don't know.
I see that, but insofar as light from that source, I'm not able to shine it at the moment. But what I would do, and this is part of the point of taking my lord and my lady through these provisions now, is to show you the shape and the structure, and just picking up and in light of what my Lord Justice Flaux said, I think I can do this very quickly. One sees in subcondition 2 at the bottom of 392 the provisions that are in fact centrally relevant to the redemption threshold amount argument. That is the process if optional redemption is engaged.
And that applies in, sorry.
Sorry. So you go.
No, I was just saying that applies in both circumstances, both at the option of the collateral manager and at the Class F option.
I'm not sure if that's right, my lady, simply because...
Well, if it's a currency, not to the redemption at the option of the collateral manager in C on 392.
I think
but
that's
currency
D,
redemption.
If it's D.
Yeah.
Yeah.
So,
but
so
it's because one sees at the top of page 393, you're looking at receipt of a direction or consent as applicable from the Class F note holders.
Yes.
But I will be coming back to that mechanism later for the arguments on the redemption threshold amount. But just to complete condition 7, one sees then that there are a number of provisions for mandatory redemption. And just heading through, or going through the
Just
headings...
going back for a moment to B2, which you sort of stated over a moment ago. The critical bit is in 393, about 5 lines down, isn't it? The collateral administrator shall, as soon as practical, and in any event not later than 15 business days prior to the scheduled redemption date,
Yes.
calculate the redemption threshold amount. What's said against you is that is a, as it were, fixed in stone. That calculation has to be made. It can't be based upon guesstimates or assessments or whatever. And that demonstrates that this is all finalised and fixed prior to at least 15 days prior to the redemption date.
Well, indeed, my Lord, and I'll be...
That's the argument against it.
Indeed, and that's what the Chancellor drew some comfort from, but not
Not
conclusively.
much. I mean, he didn't think that was a decisive.
No.
Well, in fact, my Lord, as I will be submitting in due course, it's a fundamentally bad point, and if anything, goes in our favour. But that, I think, is heading 5 of the run of substantive submissions.
Okay.
But my Lord, going back to mandatory redemption in C, and if I could just at the moment just invite your attention to the headings. Sub 1 is redemption upon breach of coverage tests. Sub 2 is target date rating confirmation failure. Sub 3 is redemption following expiry of the reinvestment period. And 4 is redemption of Class E notes on certain payment dates after August 2013. So there are a number of possible grounds. It's simply not necessary to get into the detail of them now. Only one, which is sub condition 3, involves a redemption of the Class F notes. But the point is that none of these mandatory redemptions change the waterfall from condition 3 if condition 3 otherwise applies. In other words, if an incentive fee is otherwise payable because the thresholds are met, it continues to be payable on these mandatory redemptions. And the only point that is submitted otherwise, and which the Chancellor found, is that that fee is not payable. It is said if there's a condition 7B optional redemption. It's a point that I will return to later. But in our overall submission, there is no plausible commercial reason, indeed one has not been put forward, for this supposed distinction between these different types, or these consequences of these different types of redemption. Now, condition 10 is the next one to look at this stage, which is on page 398.
I'm not just trying to understand that last submission. You were saying in each of these cases, is this right? I think you were just saying, is this for mandatory, which generally the incentive fee, you said, continues to be payable?
On redemption.
Well, yes, but that doesn't answer the question of whether you relate it to, for example, an IRR calculated by reference to what's been received prior to that date,
Oh, dear.
or what's received on that date, which, I mean, that's the critical issue,
Well,
one of the critical issues.
well, it is in fact a secondary critical issue, because the primary critical issue is simply whether, if those thresholds are met, is an incentive fee payable on an optional redemption. And at this stage, all I'm seeking to show you is that if you have final redemption, maturity, an ICMF is payable, if otherwise payable, if the thresholds are met. If you have a mandatory redemption, ICMF is payable, if the thresholds are met. But the point that's been pulled out is this suggestion that if you have an optional redemption under condition 7B, then the incentive fee is not payable because of the way the definitions work. And all I'm seeking to submit to my lords and my lady at the moment is, given the structure of the notes.
So I don't understand that language. Nobody's denying that if an optional fee would otherwise be payable because the 10% return has been met prior to that date, and, for example, the fee has been deferred for some reason, there's no suggestion that that deferred amount which hasn't been paid shouldn't be paid on that day. That will be paid.
Well, my lord, I think that's right, and that's part of my submissions later. And the part of
I'm not quite sure the point you're making. You say it won't be paid. I mean, that all depends upon whether or not you take into account, and how you take into account, distributions made at the relevant date of redemption.
Well, my lord,
So I'm slightly confused the way you're getting to on this.
well, my lord, that may be the point that it comes down to.
Yes.
But the point that the Chancellor made was that as a matter of construction, not just of these conditions, but also of the Collateral Management Agreement and the various master definitions, no incentive, what he referred to as new incentive fee, was payable on an optional redemption. And the reason for it, his primary and to some extent sole reason for it, was because on an optional redemption, condition 11, as we've seen in the priorities of payment, is engaged, as opposed to condition 3. And he said, therefore, no incentive fee, as he said, new incentive fee becomes payable. And it is absolutely fundamental to deal with that point, because it is the platform for the judge's conclusions, which he reaches later, and on which he does build in part, although possibly with not a great deal of enthusiasm, the point that my lord has just referred to.
But as I understand the point that you're making, and perhaps I'm taking it at too high a level, so please correct me, Mr. Elton, is that you're taking us through these different provisions, and you're showing that the way in which they work, and you're saying accordingly the fact that the Chancellor saw particular wording in this case which led him in a particular direction, it was because he didn't stand back and look at it as a whole. And if one does that, one can see, I think it's what you're saying, that there are infelicities in the drafting. And if one takes a step back and looks at it as a whole, it made no sense.
Indeed, my lady.
So I don't think you were saying anything great or more complicated than that.
Well, save that. The point, of course, is that one does need to understand the shape of it and the general structure.
And that's what you've been doing.
Indeed, before looking to the individual provisions. The overall shape then helps inform what the meaning of the individual provisions are.
And you say if you look at that overall shape, then there must be an infelicity here.
Indeed. I'm grateful to my lady. I was next going to refer, my lords and my lady, to condition 10 on page 398, which is a familiar form, events of default provision. And the relevant part to look at is going forward to page 400 and subcondition C, which is, again, a familiar provision for acceleration in sub-paragraph 2. And one sees there that it is open for the note holders to direct an enforcement notice to be served, which would lead to enforcement of the security and the application of the Condition 11 waterfall. Familiar territory and no issues in respect. But the position that applies, that if there's no direction from the note holders, is dealt with by condition 5 over the page. Because what is quite clear is in those circumstances, the question of enforcement is for the trustee. And one sees this from the wording, that if an issuer event of default occurs and is continuing, the trustee, except if directed otherwise by the note holders, will direct the collateral manager to retain the collateral debt securities and continue making payments in the manner described above under condition 3, unless the trustee in its sole opinion determines upon expert advice that the anticipated proceeds of sale, then if I can just skip some words, would be sufficient to discharge in full the payments required to be made pursuant to the priority of payments referred to in condition 11. In other words, the default position, if the trustee isn't directed otherwise, is that unless the assets, as a result of the collateral manager's management, are sufficiently valuable to repay all liabilities under condition 11, that's inclusive of interest and principal, the default position is to keep the issue going and apply condition 3. With the, in our submission, extraordinary result being on the judge's construction that if an incentive fee is otherwise payable, it will continue to be paid under condition 3. But if the management of the portfolio has in fact been more successful, such that the assets can pay out everyone under condition 11, then the collateral manager gets nothing. And there is again in our submission no plausible commercial reason for that supposed distinction. And it really doesn't make sense as a way to structure a performance-based incentive fee. And my lords, the other condition, and the last condition I was going to refer you to is condition 11, which is the enforcement waterfall. That begins at page 401, but with the relevant part starting just below the first hole punch on page 402. In the third paragraph down, the net proceeds of enforcement of the security over the collateral shall be credited to the payment account and shall be distributed in accordance with the following priorities of payment. And there's then a list, a shorter list than one sees in condition 3, because many matters have been combined. But the relevant point for present purposes, just to show you, is on page 403 in subcondition U, the reference to the payment of accrued and unpaid incentive collateral management fee. And of course, as is common ground and indeed observed by the judge, these waterfalls are not dealing with entitlement or liability. They're only dealing with subordination. In other words, the order in which the various liabilities are to be paid. And my lords and my lady, could I turn now to the Collateral Management Agreement in Bundle B3, tab 3, starting at page 541. And this, as you will see, is a Clifford Chance document setting out the services to be provided and the consideration payable for them.
Why are you mentioning which firms did the draft? What is the relevance of that?
Well, my lord, it's simply because, as my lord will appreciate, in transactions of this sort, there will be necessarily a firm that takes the lead on a particular document. Clifford Chance with the collateral managers.
They all agree that at the end of the day, it's all agreed by everybody.
Of course they do.
Who drafted it? It's not
Are you saying some are better drafters than others?
No, absolutely not. But what I think is legitimate is, and indeed matters, that the court will.
None of the firms involved are actually in court, are they? Because they've all changed solicitors since then.
I think that's probably right.
Alan and Overy are acting rather than White and Case, and I imagine that you're instructing solicitors are acting rather than Clifford Chance.
My lord, I'm not sure if anything could be read into that, but
Well, it may
that
be
is
that people have moved with firms, but
indeed.
even so, like my lord, I'm not sure what the relevance of that is. Anyway,
Yeah, I think well, my lord, the only point is that one knows through experience how documents are put together, and insofar as at the end of the day you may think there are infelicities and ambiguities and unresolved matters in the documentation, as Lord Collins said, these things happen in a process that is as complicated as putting together a transaction of this sort. It really goes no further than that. If I could just again show you the shape of this before coming to clause 14. Clause 2.1 at page 548 deals with the appointment of the collateral management and indeed the main obligations to identify, assess and purchase collateral debt securities. Now these are elaborated in the rest of clause 2 and indeed clause 4 and subsequent clauses, going through to approximately page 569. It's not necessary to look at the detail of those, but as indeed I'm sure the court would appreciate, there is a complex web of obligations relating to the portfolio, the criteria to be applied, what processes to be followed, part of the expertise that the manager brings to the table. My lord, clause 10 at page 574, under a heading at the bottom of the page of confirmation of the collateral manager, is a provision that requires the collateral manager to purchase 10 million euros of Class F notes and to hold at least 7 million euros until maturity or redemption. In other words, aligning the interests of the collateral manager in the risk of loss, in other words, the downside, with the Class F noteholders. One then gets at page 580 to clause 14, dealing with fees and expenses. And this is the key clause relating to the entitlement to the incentive fee. And it's the first on which I'd make specific submissions. But could I just show you the relevant wording first, which is in fact quite short. It's simply that the collateral manager shall be paid the following amounts on each payment date, subject to condition 4D, which is in fact a mistake, the cross-reference is 4C, of the conditions, and in accordance with the priorities of payment. Then over the page A is the base collateral management fee, and B, the incentive collateral management fee. Now, as to our submissions on this clause, there are 3 points which I can take, I think, briefly. The first is, as you've seen, it's in our submissions, the fee is to be paid on each payment date. One sees this at the bottom of page 580. Each payment date is defined in the master definitions. That is in tab 4 of this bundle, at page 711. But my lords and my lady will see that payment date means 1st February, 1st May, 1st August and 1st November, the maturity date and any redemption date. And redemption date is defined at page 717 at the bottom of the page, as meaning each date specified for a redemption of the notes or a class pursuant to condition 7, redemption. In other words, it expressly includes a condition 7 redemption date, no carve-out for optional redemption under condition 7b(1)(a). In other words, clause 14.1 says, going back to it at page 580, it says through the definitions, the incentive fee is payable on a redemption date following a conditional 7 optional redemption. Well, that's the first point. The second point is the word still on page 580 at the bottom of the page, and in accordance with the priorities of payment.
518.
580, I'm so sorry, my lord.
Oh, 580, back in. Sorry.
Back to clause 14.1. It says those words that we've seen right at the end of the introductory part of clause 14.1, and in accordance with the priorities of payment. Those are defined, and I'm sorry that it's a number of fingers in different parts of the documentation, but those are defined at page 715. Defined as meaning in A, save in respect of any redemption of the notes pursuant to condition 7b. So effectively you can ignore A, as it's a carve-out of 7a, but in B, in the event of any redemption of the notes pursuant to condition 7b, on and following enforcement of the security over the collateral in accordance with condition 11, the priorities of payment set out in condition 11. In other words, what clause 14.1 specifically says, going back to page 580, what it says through the definitions is that an incentive fee is payable on a redemption date pursuant to condition 7b in accordance with the condition 11 priorities of payment. So far, I think and hope uncontroversial. Now the third point, as we have seen, is a short one, and that's both condition 3 and condition 11 expressly have provision in their waterfalls for the payment of an incentive fee. And we've seen that in condition 11, subcondition U, at page 403 of bundle B2. In other words, the priorities of payment anticipate that the fee could in principle be payable in accordance with condition 11. And the prima facie position, therefore, simply on the wording of clause 14.1, which is, after all, the basis and the origin of the liability for this fee, is that an incentive fee is in principle payable on an optional redemption under condition 7b(1)(a). And as we understand it, although it's not completely clear, but as we understand it, that was broadly agreed by the judge. But the key wording relied upon by the Chancellor was in the first 4 lines of the definition of ICMF in the master definitions, which led him to the conclusion that ICMF, the incentive fee, was only payable if the condition 3 waterfall applied and not if the condition 11 waterfall was engaged. And one sees that definition at bundle B3, page 697. And it divides into a number of parts. The relevant part for present purposes being really those first 4 lines. And there are 7 brief points that I would make on it, and this is the second heading out of the 6 that I identified earlier.
So we're now moving on to point 2.
Yeah, indeed.
I'm sorry, and we're at page 697.
The definition of incentive collateral management fee in the middle of the page.
Sorry, because I'm hopping back and forth between that and the extracts in the core bundle. So.
Oh, my lady, I'm so sorry. It's
No,
it's page 140 in the core bundle.
Yeah, thank you.
And the first point, I know that my lords and my lady have read this definition probably more than once, but the first point is, in a sense, the obvious one. The second line refers again to each payment date. It's the same point as in clause 4.1. It envisages payment on an optional redemption. The second point is that there are words, the words in the second to fourth line, which were central to the judge's conclusions, which refer only to in accordance with condition 3. Now, there are 3 subpoints on this. The first is, if this is wording which limits the payment of an incentive fee to circumstances in which the condition 3 waterfall priorities apply, then it is contrary to the clear each payment date language in both the definition and in clause 14.1. Now, the second subpoint is that it is not, in fact, expressed as a limit or exclusion of condition 11. There's certainly no express exclusionary language. On the contrary, the phrase continues, my lords, my lady have seen, with a general reference to the CMA in the words, and pursuant to the Collateral Management Agreement. And the third subpoint is that it is in fact quite clear. I'm so sorry, my lord.
Third point.
It is in fact in our submission quite clear that an incentive fee is payable in accordance with the condition 11 waterfall. Because not only, as my lords and my lady has seen, there's an express reference to it in the condition 11 waterfall at paragraph U. But even if that is limited, as Napier have contended, to amounts which have been deferred, and this may be the point that my lord was raising with me earlier, even if it's limited to amounts that have been deferred from previous payment dates, they are still necessarily payable in accordance with condition 11. And my lords and my lady will see this from clause 14.1. I'm afraid it involves going back to page 581 of this bundle, or core bundle, page 179. And the part of clause 4.1 of the CMA, in the middle of that page, beginning just under the reference to the Incentive Collateral Management Fee. Because what this says is, to the extent not paid on a payment date, due to an insufficiency of funds available after application to creditors, ranking higher in the order of priorities of payment, the base and the incentive fee will be deferred and payable on the next payment date on which there are sufficient funds available in accordance with the order of priority of payment. And as we've seen through the definitions, if the next payment date is an optional redemption date, when condition 11 applies, then the deferred incentive fee is payable. But the key point in our submission for present purposes is that it is payable in accordance with the condition 11 priorities, which must mean, even on Napier's approach, that a payment in accordance with condition 11 can be accommodated in the ICMF definition. And that must be so, otherwise there would be no basis for any payment of deferred ICMF.
I'm just trying to understand that. Both the condition 3 waterfall and the condition 7 waterfall do refer to a collateral management fee being paid.
That's correct.
Yes. And it does no injustice to anybody's argument, I think, to say that where a payment of the ICMF has been deferred under this provision, irrespective of anything else, it certainly would be payable under both waterfalls.
Yes, indeed,
Right.
which is
So
our point.
Which is whose point?
It's our point, my lord. Because
Where does that get you to? I don't understand why I don't understand the leap from that point to a wider point that even if there's no deferred ICMF because it was outstanding, nonetheless you still get a management fee according to any further amounts that are transferred on that redemption date.
well, my Lord,
What is the logical connection to
my Lord, I will deal with what which the Chancellor referred to as new ICMF. If I may,
It's
in a
all
moment.
about the new ICMF, isn't it? That's what it's all about.
Well, my Lord, the construction is about how the clause actually works. And what the Chancellor said is that these words that we've been looking at in the first 4 lines of the ICMF definition limited the payment of ICMF to where the condition 3 waterfall only was engaged. And what I'm simply seeking to show you at the moment is the first 2 points wrong because of the definitions that we've already seen. But this third point, if it's right that deferred ICMF is payable on a redemption date, which is quite clearly what clause 14.1 says, that can only be payable under condition 11. And so the short point is that when you're looking at the definition of ICMF, it cannot be saying that it is only payable if condition 3 is engaged, because otherwise the deferred ICMF, when rolled over to the optional redemption date, is not payable, which was not Napier's position or indeed the judge's position.
Let's read this.
My Lord, going back, if I may, to the language of the ICMF definition at B3, page 697, or core bundle, page 140, and this is the third point in the run of 7. It's clearly accommodated in our submission in the words in the 4th line, and pursuant to the CMA. Indeed, it has to be accommodated there if the language is to make any sense. In other words, the definition would read, so far as relevant for these purposes, from the 2nd line, in accordance with condition 3C1 and condition 3C2 and condition 11. Condition 11 being in this context, pursuant to the Collateral Management Agreement. But it's a point I've already made. If it is included in that way, the definition necessarily accommodates, as you would expect, any payment of incentive fee pursuant to clause 14.1 on a payment date which engages condition 11. In other words, contrary to what the Chancellor held, and it's fair to say this point possibly wasn't deployed in quite this form before him, but contrary to what he held, the reference to condition 3 in the definition cannot in our submission be used to exclude an entitlement to ICMF when condition 11 is engaged.
Can I just try and analyse that? Are you saying that the reference here to the Collateral Management Agreement is separate from and in addition to the earlier references in this definition to condition 3C?
Well, my Lord, what it probably says in the end is that those references to condition 3C are unnecessary on the basis that pursuant to the Collateral Management Agreement could encompass that as well. But what I
said against you, that if you use the word or rather than there'd be more force in your point.
well, my Lord,
What you're trying to say is, well, never mind that it's not within condition 3, I can get it in under the Collateral Management Agreement route. To which an answer might be, well, no, you can't, because it has to be both within condition 3 and pursuant to the Collateral Management.
yes,
Well, that must be right, because as you quite rightly said, the governing contractual provision is 14.1 of the CMA.
yes, indeed.
So you couldn't have a situation where there was no reference to the CMA. It wouldn't make much sense.
Right.
Now you say the reverse, which is certainly true, which is, it could simply have said pursuant to the CMA, and then you wouldn't need anything else. We have to think about that. But I don't think it's an answer to my question where there are references to condition 3 and pursuant to the CMA. And my question to you was, are you saying the reference to the CMA is something which is additional and separate from those?
Well, my lord, in relation to this, to condition 11, it must be.
Right, so
Because the test is through the deferred incentive fee, which is accepted, seems to be accepted not only by the judge, but is Napier's contention before him, and indeed, I believe, before this
what
court.
it really comes down to, I understand all this. I mean, this is very refined stuff, really, isn't it? But I'm trying to see whether you're saying that a more felicitous drafting could have, I suppose, simply would have said, in accordance with paragraph condition 3C3, blah, 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 or condition 7, as the case may be. That would have been better drafting from your perspective, would it?
Well, my lord, I can think of a number of ways in which it could be better drafted, but it's dealing with the wording that has been used to try to make sense of it, as the cases tell us.
No, I know, but I'm dealing with the infelicity point.
Yes.
We've got Lord Collins, and it's a pretty obvious point, which is sometimes in these very complex documents people make mistakes.
Yes.
Difficult is knowing whether they've made mistakes or whether in negotiations they've seen a point and decided not to take it. That's always the difficulty.
Yes.
So to make sure you're not reopening the negotiations that others have conducted.
Yeah.
That's the great danger. But all I'm saying is that it would have been, if there is, I think you accept in answer to my lady's earlier point, yes, there are infelicities here.
Indeed.
And we don't need to shy away from it. That I think your case is, the infelicity is a reference to condition 3 when it ought to, we can say it should have referred also to condition 11. I think that's what it comes to.
Well, my lord, either that, because to marry up with clause 4.1, it would be in accordance with the priorities of payment, which is condition 3 and condition 11. Either that, or simply no reference to condition 3C1 and condition 3C2.
That's how I understood what you were saying, that in effect we should read the definition as if those lines were not there at all because they're not necessary, and that one should just read it as means the fee payable to the collateral manager on each payment date pursuant to the collateral management agreement.
Indeed. And I will be showing you other wording where that technique is used. But the fourth point, if I may move on, which is one already touched on, so I can take very briefly. No plausible commercial reason.
So it goes to the fourth main point, are we now?
My lord, this is fourth out of the run of 7 under the second heading.
That's right, that's fine. Okay.
Or something of a magic eye puzzle, and I don't apologise for some of the refinement on this. There are a number of detailed issues that actually need to be addressed. But the fourth point here is the one already touched on, that there's no plausible commercial reason, at least none has ever been suggested, for the incentive fee being payable during the currency of the transaction and on maturity and mandatory redemption.
Just don't go too fast, sorry. No sensible, there's no
Plausible commercial reason.
commercial reason for the incentive fee to be payable during the
Currency of the transaction and on maturity and on mandatory redemption, but not on optional redemption by the Class F Noteholders. And in each case, the performance of the note and the notes and the result to the Class F Noteholders, by which the reward to the collateral manager is calculated, depends on the skill and judgment of the collateral manager. And it is, in our submission, just illogical that a performance-based incentive fee should be applicable in all those situations, save optional redemption. Or put another way round, there's no plausible commercial reason for an optional redemption to give the Class F Noteholders effectively the right to assume 100% of the equity.
So last point again.
My lord, the way in which the investment fee works is that it's effectively 20% of the equity after the thresholds have been met.
Yes.
And the effect of the judge's construction was that an optional redemption effectively gives you the right, the Class F Noteholders, the right to assume 100% of the equity. My lord, the fifth point in this run of 7 concerns the Collateral Manager termination amount.
Well, I'm just trying to understand. You say assume 100% of the equity. I mean, in certain circumstances. So before you get to the optional redemption, you've got a number of payment dates.
Yes.
On each of those payment dates, assuming that you reach the right level of return, IRR,
Yes.
then an incentive fee is payable.
Yes.
So they won't receive 100. When you say they receive 100% of the equity, I'm not quite sure what that means.
Well, my lord, looking
An
at
incentive fee will have been paid if the IRR has been reached throughout the whole of the run of the, or throughout whatever is the appropriate part of the run of the period. What it does mean is that they receive 100% of what's left
my lord,
after, on the date of redemption, after the other note holding priority have been paid off. That's that what you mean?
Indeed, my lord. My lord has a point exactly.
It's the 100% of the equity that's left on the redemption date.
Yes, of the residual amount. And I'm sorry if the shorthand I used didn't help clarify that point.
Your fifth point.
That's the Collateral Manager termination amount, the CMTA, which, as my lords and my lady will have seen, is another fee potentially payable under the Collateral Management Agreement. For this one needs to go to page 585 of Bundle B3 and clause 18.1 is where it starts. This deals with the term of the Collateral Management Agreement, and its core bundle, I'm sorry, page 181.
So we're going back.
My lord, yes. Sorry,
It's
this
not
is...
B35885.
No, it is B3585, just for my lady who I know
Oh, I'm
is
so
following it
I'm
in
sorry.
a different bundle.
No, well, I am.
I thought I should give the other
Thank you.
reference.
Yes.
Um,
We're looking at which definition here?
Well, it's clause 18.1 first, sets out the term, as you can see, of the CMA. It's until distribution of proceeds to the note holders. In other words, there's no doubt that the obligations under the CMA continue after the optional redemption is made until distributions are made. Clause 18.3 provides for termination with cause, but going forward, if I may, to page 589, clause 18.8 provides for termination without cause.
Hang on. 589.
And clause 18.8 and as one sees from clause 18.81, this can be done on 60 days notice, and in 18.8.2, as you will see, if the collateral manager then is a Babson company, then it's entitled to receive the collateral manager termination amount in accordance with the priorities of payment, and A is a one-off variant of the base collateral manager fee, which we will see later. But B is the important one. It's subject to 18.83 below. On each payment date, the issuer shall pay such Babson company an amount equal to the sum of 20% of the cumulative subordinated income in excess of the principal amount of the Class F secured income notes. And then it deals with value added tax. And then 18.83 has the other threshold that we've seen in relation to the ICMF of the secured income threshold. Now, the point in relation to this is that B is designed to replicate the economic effect of the incentive fee. Hence, you have it payable on each payment date in accordance with the priorities of payment. It's at 20% of the CSI in excess of the Class F notes principal, and exactly the same formula as in the ICMF definition in relation to the secured income threshold. But the important point for present purposes is that this fee, the CMTA, is payable on each payment date in accordance with the priorities of payment, in economically the same amount and on the same threshold conditions as the ICMF. But it has no language, even arguably limiting it to circumstances where the condition 3 waterfall is engaged, either in clause 18.8, which we've seen, or in the definitions. And I'll ask you for these purposes, please go forward to page 677, where one sees in the middle of the page the definition of collateral manager termination amount.
I'm sorry, you're going to have to give me that page number again. I'm sorry.
I'm sorry, my lady, it's B3, page 677, and
Thank you.
this isn't in the core bundle.
No, it's not.
But the collateral manager termination amount is provided to mean the amount determined pursuant to the collateral management agreement payable to the collateral manager in respect of termination of its services. And the short point, indeed the words pursuant to the CMA make it quite clear that it's payable on a redemption date brought about by an optional redemption. But the short point here is that there can be, in our submission, no possible logical or commercial reason for this fee, which is payable once the collateral manager ceases to act as the collateral manager, being payable on a condition 11 redemption date, but the incentive fee not being payable.
But can we just understand, I haven't really looked at this before, so it's in detail. I mean, I read the Scottish Noel about it, but I didn't actually look at it. So can I just understand exactly how this works? So this is a case where a notice is given by the issuer to terminate without cause.
Yes.
Now, who can? Is it just who can trigger this? Does the issuer have to act on the instructions of so many of the note holders? How does it work?
Lord, I'll have to look that up. I do think that the note holders have the ability to force it.
But I think if we're going to look at how other things operate, then I think we really need to understand exactly how they operate. Looking back, it's very difficult just taking bits and pieces here.
I understand that.
So
If
anyway,
it's an optional redemption, is there necessarily a termination without cause as well?
No.
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 That's
We're
right.
actually dealing with different situations.
it's a different situation. That's what I'm asking. I'd quite like to know how it operates.
No, I'm so sorry. I haven't made the point clear that I'm trying to communicate. It's a different point.
No, I think I certainly got that from the Scottish Noel. You're making a comparison. But anyway, it's not clear to me exactly who governs this in the circumstances, but leaving that aside, because I'd like to know that. So the issuer, presumably prompted by somebody or other, then serves a notice, and it's a 60-day notice. So, so if at the time of the notice it's a Babson company, just remind me what that is.
My lord, it's a group of companies involved in asset management and various other financial.
So then it shall, in addition to any other amounts owing to under this agreement, and I don't know what these other clauses deal with, but there's various other clauses, be entitled to receive all of the following fees, and then it specifies them, plus VAT, in accordance with the priorities of payment. Now you're saying the priorities of payment applicable here is 11, is that right?
No, my lord, it could be condition 3, it could be condition 11. The priorities of payment are defined as condition 3 and condition 11. The transaction, in these circumstances, continues to run. It may or may not be...
Continues to run for 60 days.
No, my lord, it's the collateral management, or the engagement of the collateral manager under the collateral management agreement continues for 60 days. It's a 60-day notice to terminate the collateral management agreement
So-
without cause.
So the idea is that they then get somebody else in, is that right?
Yes,
Yeah.
indeed.
So it's a 60.
85 's about.
Oh, I haven't got that far.
The opening words for 18.8.1, subject to clause 18.5, make it clear you can't do any of this unless you line up to success.
Absolutely.
So this isn't dealing with redemption at all.
No, that's what I'm trying
Dealing
to
with continuing.
Can I just go?
portfolio.
Can I just work this through in my own kind of slow way? So then, what you do is on the first payment date, following the date of the notice, you're giving a certain amount. That date, and it's calculated by reference to the previous 12 calendar months.
Indeed.
And that's the first thing,
Indeed.
right? Then we're going on to payment date following the date of the notice, and presumably that's for the next 60 days until that expires. Is that right? That's what you do to assume.
Well, it's
It's not going to
payment.
be going on forever. Already going on forever.
Under A, it's a one-off payment.
Yes.
Under B, it is on each payment date until payment dates stop. It's a continuing payment.
So irrespective of the 60 days, I mean, even while it continues even after they've been removed.
Yes, and that
It
is
carries on until the end of the transaction.
indeed,
Right. Okay.
and that's the crucial point.
So
Payable by-
therefore,
Sorry.
so therefore, the assumption must be condition. If I'm wrong about this, condition 11 can't possibly apply because there's no redemption.
No, my
It can
lord,
only be condition 3.
no, my lord, not at all. The transaction continues.
Yes.
As it continues, condition 3 applies.
Yes.
And as I will show, my lords, there's reference to the CMTA being payable in condition 3. If the transaction ends for whatever purpose, maybe maturity, maybe mandatory redemption, optional redemption, or enforcement, but if it ends in circumstances where condition 11 applies, then of course, in accordance with the priorities of payment, this fee is payable under condition 11, and there is an express paragraph which provides for the payment of this fee under condition 11 as well. So, my lord,
Where do we get all that? Let's just carry on down here. So at some point, presumably, if it's not redeemed earlier, it'll mature, I assume, if it goes on forever.
my lord, yes, maturity date is in, I think, 2022.
So at some point, it's going to come to an end. You're saying that despite the notice being only a 60-day notice, the collateral manager is entitled to this B payment, 18.82B, right up until that date, whatever it is.
Yes, it's absolutely clear. It's on each payment date, which includes, as we've seen from the definitions, each redemption date.
Right, and then, so at the moment, there's nothing saying specifically about what happens when the whole thing comes to an end.
Yeah, my lord, there is, because going back just above subparagraph A, it's in accordance with the priorities of payment.
Right.
And if the issue will come to an end, if condition 11 priorities of payment are engaged, because they will be engaged if there's a redemption or if there's enforcement.
Right.
It will come to an end in other circumstances, such as maturity or mandatory redemption, where condition 3 will still apply. But what one needs to do, I would suggest, is just to look at the operation of this additional fee. It is clearly intended to be economically equivalent, and one can see commercially why it is, economically equivalent to the incentive fee. But the point is, and it is the big point, that the wording that the Chancellor latched onto in the definition of ICMF, in the second to fourth lines, the reference to condition 3, is just nowhere to be found in relation to the collateral
No, I understand, that's why I'm
management.
trying to understand how it works. Excuse me if I've been slightly slow, I'm just trying to work out exactly how this is operating.
Well, indeed, ma'am.
So as I understand what you're saying, after the collateral manager's been removed pursuant to this notice, and some other collateral manager's been appointed,
Yes.
this collateral manager, the one who's been booted off, continues to receive the equivalent of what they would have received under the incentive fee.
Indeed.
But what does the new person get then?
A modest, comparatively modest, ongoing running fee for the management, which I think is set at 20 basis
So
points.
the new collateral manager doesn't get an incentive fee at all.
That's right.
Well, that seems very odd in itself.
Well, when I say that's right, it will depend on the commercial negotiations which the new collateral manager makes with the issuer, the trustee, and anyone else.
Well, I mean, they're bound to ask for an incentive fee, aren't they?
Well, my lord, the hard work, a large part of the hard work, is in assembling the portfolio, then dealing with it. It's not envisaged. Nobody envisaged that this was going to end rapidly. But once the portfolio is up and running, at the end of the reinvestment period, end of the ramp-up period, once it's up and running, one can see that a collateral manager, effectively for dealing simply with the ongoing position under the notes, may commercially be more prepared to have a running fee rather than an incentive fee. But that would be a matter for negotiation with the new manager.
So, Mr. Elton, you're saying that there aren't any other provisions anywhere that we should be ferreting out and looking at in relation to new incoming manager. It's just all the provisions that you've referred us to. But you're saying commercially, no one in their right minds would agree to pay an ICMF to the incoming person when they're paying a fee under 18 to the outgoing person, a CMTA of this magnitude, and accordingly it's likely that they just agree something modest.
Well, perhaps I should show you to the definition of the replacement collateral manager fees, which is on page 720 of bundle B.
Aha.
But is the let's look at that. But just I think what it comes down to, even as read, what you're saying about the economic comparability of this to the incentive fee, what you're saying is because there is no express reference to either condition 3 waterfall or the condition 11 waterfall, there's no possibility of a limitation such as the Chancellor implied for the incentive fee from the definition of the incentive fee.
Indeed.
That's what it comes down to.
My lord, it's turned into a longer point than I anticipated.
It is quite common. You've been living with this. For us, it's quite a complicated thing to understand.
I fully understand, but ultimately that is it. And you work through those definitions, and one comes down to the short point as to if this termination amount is payable once the collateral manager ceases to be collateral manager, and it's payable on a condition 11 redemption date.
Yes.
But the Chancellor says, well, the ICMF, the incentive fee, isn't. There's simply
So the answer is what we've got to look for in due course. Really, for Mr. Wilson, what we've got to look for, you're saying, is either some reason why commercially this is a different situation,
Yes.
or it's not economically comparable,
Yes.
or some other explanation of why there should be some difference. That's what we've got to look for. That's what you're saying.
Indeed. And Mr. Wolfson's point is it's not the same, but he hasn't elaborated in his skeleton why he thinks it's not, if indeed he does think, not economically comparable.
Why is the new collateral manager on this assumption who gets appointed pursuant to 18.5 not entitled to the incentive collateral management fee as defined going forward?
Well, I think the answer to that, and I'm sorry, I might have slightly collapsed a number of things earlier, is that the provision of the collateral management agreement says that the replacement collateral manager will get the replacement collateral manager fee. One sees that actually from clause 14.1 on page 581. And it's a paragraph just above the second hole punch, where one sees that in the event that the collateral manager is replaced pursuant to clause 18, which is one we just looked at.
Hang on. 581 under in A or B? B.
My lord, it's just above.
Oh, I see. I've got it. Yes, I see. Let me just read that. Clause 18. Yes.
So in other words, if Barings go, the replacement collateral manager gets the replacement collateral manager fee on each payment date and in accordance with priorities of payment. And that is defined at page 720, which is, again, on each payment date pursuant to the collateral management agreement. This is 0.2% per annum of aggregate principal balances.
That's the replacement collateral manager fee.
So your point really is that the old collateral manager gets the lion's share.
Well, my point
And
simply is,
the new people get a very small share.
my lord, my point is not having any interest or actually care about the replacement collateral manager. But the point in at this stage of the argument is that on the judge's construction, we do so much better by being terminated and not having to do anything. Because if we continue, we're not going to get the incentive fee when there's an optional redemption.
No,
but we will get the commercial manager's termination amount.
Well, okay, I understand that. I'm going to be a slight devil's advocate because I can hear what you're saying. But if we take this as literally read, what you said seems absolutely right, which is the reality of it is, if you're going to sack your initial manager, collateral manager, you've got to be aware that you've got to have somebody lined up. And I would be extremely surprised if they were going to simply accept this minimal payment. And so what you said is it depends on the negotiations, which I think let me just finish. So somebody rather cynically might suggest that this is worded in a way which acts as a strong disincentive ever to sack your collateral manager, because you're going to be placed in an extremely difficult position if you do that.
Well, my lord, that may be so, but the problem is that there's no material, I think, that's available that enables us to either
That's
say
why we have
that's
to be
right
very,
or
very
not.
careful about this.
But my lord, what can be assumed is that all the parties agreed to these terms. And although it's a Clifford Chance document, as my Lord Justice Flaux made sure we remembered, these are documents that go back and forth. They're signed up to by anyone. If there's that sort of commercial edge in it, there may be, but equally it's one that the other parties were happy to accept.
Well, I understand that, but I'm just we're all trying to deal with the commercial realities. That's why I'm trying to dig down into this. And I've to spend a bit of time on it because what you presented is very, on the face of it, a very compelling argument. But I'm just trying. We haven't looked at as much detail as the other because this isn't right at the heart of the case. So what I want to understand is this: when these documents are being drawn up, am I right in thinking that the collateral manager is a vital person, a vital party to these documents in their original form?
My Lord, perhaps I could answer that in two ways. The collateral manager is vital to the transaction
I understand that.
because of the portfolio and everything else. As regards the documentation, as I showed you, I think there's 18 agreements and documents. The collateral manager will be interested in whatever relates to the collateral management agreement, and obviously. And because the collateral management agreement pushes one into the master definition schedule and then into the conditions and the trust deed, the collateral manager will have an interest in relation to those.
Who is drawing? Just trying to. Who is drawing this up? Who is producing this transaction for note holders? I mean, you're selling them in. Basically, you're making your money by issuing these notes, and you're getting whoever's dealing with them, the issuer and the manager, are getting a fee out of this. I mean, that's how they make their money. They produce the transaction and they sell it to note holders who are themselves getting a return on it. Everybody hopes to make a profit out of it altogether. But what I'm trying to understand is, at the inception, is there a commercial relationship between the various people who are drawing up the documents, which are going to be sold in the form of the notes to the note holders?
Well, my lord, perhaps I can answer that by just saying that transactions of this sort will always have an arranger, and the arranger for this was Citigroup. And Citigroup will put this together by engaging potential trustees, potential collateral managers, and whoever else may be relevant for the purpose. So, yes, the collateral manager is central. The trustee, of course, is central as well. But how that would necessarily help on the commercial dynamics on negotiating clause 18.8, I'm afraid I can't.
Well, one would have assumed that the original collateral manager, who's one of the parties engaged at the outset, I would have thought, would want to be satisfied with the terms of these documents.
Yes.
So they would want to be involved in some way or other with them.
Indeed.
Right.
And
So they would have been, so the collateral manager might be expecting its own interest to have looked at these documents with its own interest primarily in mind.
well, as my lord has seen, the collateral management agreement is, the pen is being held by Clifford Chance, the collateral managers then solicitors.
I see.
The pen, I think, on the other documents that are relevant here is held by White and Case, the trustees' solicitors. But the point my lord makes is clearly and obviously right, that the collateral manager will be interested in anything that will relate to or impinge upon its rights under the agreement that governs it.
So I'm interested in two aspects, and so I'm sorry to dwell on this because it's quite an important point, actually. Yes. I think, a pointer for you. The first is that I think it would be, if I had to make any assumptions at all, and there's no evidence about it, so you may say we can't make any assumptions, but if I were to make any assumptions at all, you would imagine that the collateral manager would want to ensure that it can't be sacked easily. I mean, that seems to be an obvious point.
Possibly, my lord, but one of the best ways, of course, of doing that is by performing well.
Of course. No,
And the commercial imperatives in transactions of this sort, the collateral manager would never be sacked if he's performing well. One can't, unless there were some...
Of course, I totally understand that. It would be helpful to me if somebody behind you could find out in what circumstances the issuer can issue this notice. I.e., is it on the basis of a certain percentage of the note holders saying so, or is it on the issuer's own say-so? It would be quite useful for me to understand the background to that point.
I fully understand that, my lord, although, of course, my primary submission will be, whatever the answer is to that, one has the structure in relation to the fee. So however the notice is caused to be brought about, one nevertheless has the consequences of it. And it's the consequences, excuse me, it's the consequences of it which are important for...
No, I understand that, but at first sight, I'm putting these points because I think you need to answer them. I mean, if one was being cynical about it, at first sight, it seems really quite extraordinary that somebody who might, for whatever reason, and we don't know the trigger, might be sacked with a 60-day notice after, say, 2 or 3 years, with the transaction still to run for another 10 or 12 years, that they would continue to receive exactly the same incentive fee throughout the whole of that period, but a new person, subject to negotiation and negotiation, is going to receive something much smaller, and presumably, if you have to pay something more to the new manager, that's going to diminish what the Class F note holders receive at the end of the day because it's coming off their amount.
It probably would if the waterfalls were changed. But of course the waterfalls only apply to the replacement collateral manager fee, which is in the terms that are identified. So it couldn't have that effect unless the Class F note holders and others involved with the documentation were to agree to it. There would
Under the waterfalls, well, I suppose, yes, you'd have to renegotiate. Yes, you're quite right. So you'd have to negotiate quite a change. So assuming that, I mean, difficult to imagine any person new coming along with the prospect of another 10 years receiving that very small amount of money. So you'd have to have a renegotiation of some sort, which would then say where this new incentive fee, additional incentive fee, would appear in the waterfalls.
But my lord, that of course then assumes that the replacement collateral manager if one gets to that situation, wouldn't actually commercially be happy with the fee that's provided here. And there would have been...
It seems somewhat unlikely, doesn't it?
Well, my lord, I don't think the court's in a position to draw that conclusion. What you can see is that there's a difference between the fee that the replacement manager gets and the fee that the original manager gets.
Yeah.
But
Striking in this context, if we go to the issue under condition 7 of optional redemption,
yes,
that so the condition 11 waterfall applies.
yes,
In fact, the replacement collateral management fee rates quite high up.
it does indeed. My
It
lord's
comes as
seen
E,
it. Yes,
whereas the collateral management termination amount comes at T immediately before the incentive collateral management fee.
and my lord, one can
So if
see.
you have a replacement manager, he rates or they rate much higher up the list of priorities.
One can see the commercial reasons for that. I mean, the trade-off, maybe it was circumstances in which there's termination without notice, could be because of concerns in relation to performance. So the replacement collateral manager is given a higher place in the priority to make sure that the fees are actually secured. But my lord, I'm very conscious of the time. There's a lot of, I'm afraid, material still to address.
We're doing rather well. We've got to number 5 out of 7.
My lord, but 5 of 7 on heading 1. Sorry,
Oh,
heading
I see.
2 out of 6. So, my lord, if I may, as my lord has the point on this 5th, which is, it's our submission, a very strong indication that the Chancellor was wrong in his view. But the 6th point that comes out of it is that the language used in relation to the collateral manager termination amount also punches the point made by the Chancellor in paragraph 38 of his judgment, where what he did was to contrast the wording of the ICMF definition with the base collateral management fee definition. And as you will see from that paragraph of his judgment, the Chancellor considered that there was some significance in the fact that the base collateral management fee definition refers to each payment date pursuant to the CMA, while the incentive fee definition has its reference to condition 3. But as my lords and my lady have seen, the absence of such a reference in the collateral manager's termination amount definition shows that there's no magic or significance at all in that.
Absence of what?
It's-
What absence from the collateral CM
My lord, it's the significance that the Chancellor put, and one sees this at the end of paragraph 38 of his judgment, by saying some meaning must, I think, be attributed to the different approaches adopted by the draftsman.
Yes.
Being in ICMF, there's this reference to condition 3 and pursuant to the CMA,
Yes.
but with the base fee, it's just and pursuant to the CMA. And the short point
I
is
see.
the collateral management termination amount, and indeed, as we've seen, the replacement collateral manager amount refers to pursuant to the CMA. And the final point, the 7th point under this heading, is just to ask the question, which indeed I've already asked earlier, as to what is the purpose of the words referring to condition 3 in the ICMF definition. And the answer, we think, is that they're probably just flagging the fact of subordination in the ongoing waterfall, which of course is where most payments might be expected to be made. But the technique,
The probable reason is what?
it's flagging the fact of subordination in the ongoing waterfall,
Yes.
which is where most payments might be expected to be made. But the technique, whether it's deliberate or otherwise, is also used in respect of Class F additional interest. My lords and my lady, for this one needs to go back to bundle B2 and condition 6A2 that we looked at very briefly earlier this morning. It's page 385. Page 385 at the top of the page, condition 6A2, which is dealing with, in relevant part, picking up in the second line, payments of additional interest will be made on the Class F notes, defined as additional interest, on an available funds basis in accordance with condition 3C1 and condition 3C2 on each payment date, and shall continue to be so payable in accordance with this condition, notwithstanding redemption in full of any Class F note at its applicable redemption price. Now, it is quite clear that this additional interest, which ultimately is the way in which any surplus above the principal on the Class E notes is distributed back to the Class F note holders, and one sees that from condition 11. But it's quite clear this interest is intended to be payable in a condition 11 situation. And in fact, just going forward to page 403 of the bundle, I should make that good by just pointing out subcondition W. This is in the condition 11 waterfall.
This is page
3.
403. Same volume.
Same volume, yes, indeed. And W, after you have had in T the collateral manager termination amount, in U the incentive collateral management fee, in V you've got effectively the principal on the Class F secured income notes, and in W you then get interest, including additional interest. And so it is quite clear that that interest is intended to be payable under condition 11. It's a way of pushing or distributing surplus proceeds to the Class F note holders. But the short point is on page 385, when identifying what that interest is, it's done by reference to payments in accordance with condition 3 on each payment date. And it just doesn't mean that, literally. Because on each payment date, that includes redemption dates. And it clearly means, and is not, I think, in doubt, that it's intended that it's going to be payable, including on an optional redemption. And so the short point is, in our submission, it's just wrong in the context of this documentation to read too much into the reference to condition 3 in the ICMF definition. And as we've sought to show as a matter of language, it does not work, that reference to condition 3, as a limit or exclusion of the circumstances in which the incentive fee is payable under clause 14.1, and checking against the commercial implications of the construction favoured by the Chancellor, there is in our submission simply no plausible commercial reason for it to be limited to condition 3 payment dates, particularly when its economic equivalent, the CMTA, has no such limit.
I suppose the point that might be made, again if I connect with the Deputy Advocate in this purpose, is that what you say is true in relation to 6A2 and in particular this additional interest, Class F secured income additional interest, which is mentioned in W of the waterfall on the left. But one difference is that the last 3 lines make clear that it's to be paid continuously. The last 3 lines say in 6A2, and shall continue to be so payable in accordance with condition 6, notwithstanding redemption in full of any Class F secured income note at its applicable redemption price. So you actually do have an express statement here, following the reference to condition 3, which also picks up redemption.
Indeed, my lord, I fully accept that. But the point is, in looking at the definitions, which includes by on each payment date, and the language here is, again, perhaps just another infelicity, but it is, shall continue to be so payable in accordance with this condition 6. In other words, it's in accordance with condition 3C on each payment date. And my lord, it's in the scheme of things, you may think a small point, but nonetheless, in the matrix of trying to work out what is meant by the ICMF, it's another pointer, we say, against the view that the Chancellor took.
So can I just, to pick up these, in addition to the two we've spent some time, so we've spent some time on this one,
Yes,
another pointer.
yes,
We've spent some time on what happens when there's a redemption, when there's a notice sacking the manager,
yes,
that situation.
yes.
So that's those two. Just remind me, so I've got this clearly in my note, what other pointers are there from, as it were, other parts of the documentation that you refer to make sure I've got them?
Well, we essentially we have the main pointers, apart from the, if you like, the more detailed linguistic points that I've made in relation to the definition of ICMF,
Yes.
which includes payment date, priorities of payment,
I've got
and the
all
like.
that. I'm looking at something outside that. You can say, well, yes, but look at that clause dealing with something slightly different, but
And there was also the deferred, what I'd call the deferred ICMF point,
oh yeah,
or deferred actually fee point, which again is a pointer. In fact,
that's payable under both, under whether or not it's condition 3 or condition 11.
but my lord, it's actually more than a point of that, because it actually means as a matter of construction,
Yes.
the ICMF definition must accommodate condition 11.
Yeah.
And so you have, if I can label that as the deferred interest, or the deferred fee point, there's the collateral manager termination amount point. There's the point we've just looked at in relation to the additional interest to the Class F Noteholders, and various points wrapped in. I did also make a point in respect of the base collateral management fee definition and the contrast between that the judge thought was relevant, between that and the incentive fee definition. But my lord, those were our submissions in respect, I'm afraid, only of heading 2 of the ICMF definition. But I hope very much that the other headings will be much more rapid. And if I could move then to the third heading, that of the CSI. And one of the matters relied on by the Chancellor as supporting his construction was that the definition of CSI, which features, as we've seen, in the ICMF definition, and perhaps I should just show you again, it's B3, page 697, or core bundle, page 140. And this is, having addressed you first of all on lines 2 to 4, the CSI comes in really in lines 5 and 6. And it appears there as the metric against which the incentive fee is to be quantified. And the CSI definition itself is at page 679 of this bundle, or page 139 of bundle A. And I know that my lords and my lady will already have read this possibly more than once, but what it does is it effectively provides for a sum which is calculated by taking interest and principal proceeds and deducting, as one sees in 4 of the cases, there are in total 5 subparagraphs built in, or subclauses built into the definition. And in 4 of those cases, certain sums payable under various paragraphs of the condition 3 waterfalls are referred to and are to be deducted. Now, there's no deduction in relation to subparagraph 3 in the middle of that definition, which relates to proceeds from collateral enhancement securities and equity securities. And that's simply because those are particular discretionary investments by the collateral manager, proceeds of which go direct to the Class F noteholders outside the waterfalls, and so it's not necessary, I think, to spend any time on them. Now, the Chancellor thought that these references in the other four subclauses meant that a CSI calculation was not envisaged on an optional redemption because there was no reference to condition 11 or to deducting amounts paid in priority to Class F noteholders under condition 11. Now, he was, with respect, wrong in relation to this, and there are 3 points to make under this heading. And the first is simply standing back. It's in our submission quite informative just to look at what CSI stands for. It is cumulative subordinated income. In other words, it is targeting for the purposes of the incentive fee and the collateral manager termination amount, which use exactly the same metrics in this respect. It's targeting the cumulative income that is receivable by the Class F notes, or would be received but for the deduction of the incentive fee or the termination fee. Hence, the specific paragraphs that are referred to from condition 3 in the CSI definition are all those paragraphs that appear prior to the Class F note holders or the collateral manager distributions. And one can see that if I could invite my lords and my ladies to have bundle B2 open at the same time as this definition. And it's B2 at page 370 first, which is the condition 3C1.
So just give me the reference on
370, my lord.
370.
370.
Right.
And this is the condition 3C1, interest waterfall. And as one sees by looking at the cumulative subordinated income definition, the paragraphs to be taken out, or the amount payable under the relevant paragraphs, are A to FF. And you'll see by looking on page 370 that the last one on FF deals with interest on a collateral manager advance. But then you're talking about, and the detail of this doesn't matter at the moment, it will for different purposes later, but then you're looking in GG at payments to the Class F note holders. In HH, you're looking at payments to the previous collateral manager of the collateral manager termination amount. And in II, you're looking at payments of the incentive fee and of interest to the Class F note holders. So what you're doing in the CSI definition is effectively taking out all those distributions before you get to the collateral manager and to the Class F notes. And the same one can see in the principal waterfall at page 374, principal proceeds waterfall. The CSI definition ends this at Y, which is in fact at the bottom of page 373, again dealing with advances from the collateral manager, but Z picks up the first distribution to the Class F note holders, then you get the collateral manager termination amount, and then the incentive fee, and then the Class F note holders again. And the purpose, we would suggest, is quite obvious. The performance fee, the ICMF, is based on a percentage of returns to the Class F note holders. So the purpose of this mechanism is to identify those returns. Now that was the first point. The second point is that it is necessary, going back to the CSI definition, at bundle B3, page 679, to look at the sums from which the deductions are to be made for the purpose of identifying those returns. And those are, in substance, the defined interest proceeds and the defined principal proceeds. My lords and my lady, interest proceeds are defined at page 702. And you'll see that they're defined with respect to any due period, which I will show you in a moment. And then there's a long list of various different payments. One sees, for example, under E, all payments of interest received, and under C, all payments of principal received to the extent the relevant eligible investments were acquired with interest proceeds. And there's a long list of what counts. But due period is defined at page 684. And one sees that it means with respect, again, to any payment date. It's a period commencing on the day immediately following the 5th business day prior to the preceding payment date, and ending on the 5th business day prior to such payment date, or, in the case of a due period applicable to the payment date, which is a maturity date or a redemption date, ending on the day preceding such payment date. In other words, it applies specifically for the period immediately prior to a redemption date, including an optional redemption. And that, of course, would be when condition 11 may be engaged. And there's absolutely nothing to exclude a redemption date consequent on an optional redemption. I'll come back to the significance of that, if I may, in a moment, but just to show you the principal proceeds definition, that's at page 713. And again, that's the bottom of the page, it's with respect to any due period, with all payments of principal, as one sees under A. B on the top of the next page includes certain payments of interest, if they come from instruments or investments that are proceeds, have been acquired with proceeds from interest. And in D, just to flag this one, it includes all disposal proceeds received by the issuer during the related due period. In other words, these are the proceeds which will be distributed in accordance with the condition 11 priorities on a payment date which engages condition 11, including on an optional redemption. And that is a point expressly recognised in the prospectus, right? I think this would be the last reference to the prospectus, but it's bundle B1 at page 15.
B1.
Bundle B1, page 15, my lord. In the priorities of payment section halfway down the page, one sees the first bit is prior to enforcement and optional redemption, I'm asked to add, but the important paragraph here is the next one. On and following enforcement or optional redemption, in the event of any redemption of notes pursuant to condition 7b or following enforcement, interest proceeds and principal proceeds shall be applied in accordance with the priorities of payment specified in condition 11. So, my lords and my lady, going back to the CSI definition at B3, page 679, or core page 140, you are looking there at proceeds which are distributable under each waterfall, not just condition 3 waterfalls. My lords and my lady, that was the second point.
just want to make sure I understand that point. Just one moment. So what this comes to, you mean because of the definitions you're saying of in the CSR, is right, as they define, it's clear that they apply also on under condition 11.
Indeed, my Lord has the point exactly. Interest proceeds and principal proceeds, and taking for these purposes only the phrases 1 and 2, those are defined, and those are clearly the proceeds that are distributable, not only under condition 3, but also under condition 11. And the third point, in a sense, the important point here, relates to the consequences of this. Now, Napier's submission, which the Chancellor accepted, was that the absence of a reference in this definition to deductions under condition 11 must mean that the definition is contemplating only being engaged if the condition 3 waterfall is run. The reason given being that it would be absurd to take into account the full amount of interest and principal proceeds distributed under condition 11 without any deduction for distributions that went elsewhere, in other words, other than to the Class F Noteholders. Now, we would agree that it would be absurd to take condition 11 distributions into account without any deductions, because doing so would not identify the cumulative subordinated income to the Class F notes. It would instead identify the gross distributable interest and principal proceeds on the redemption date, and that's not the target of the CSI. But in our submission, the answer to this is simply not to mangle the definitions of interest proceeds, principal proceeds, due period, or redemption date, and to produce something, as the Chancellor did, that equally doesn't identify the cumulative subordinated income, because it disregards anything that is in fact distributed to the Class F notes under condition 11. And the answer instead in our submission is to read the references, or the reference I should say, in the CSI definition to amounts payable, which you see in a number of places, but first in line 3. The answer is to read those references to amounts payable under particular paragraphs of condition 3 as references to the liabilities identified in those paragraphs. That does no violence at all in our submission to the language, or present any difficulty in identification or calculation, because the liabilities which are paid prior to the Class F notes in the condition 3 and condition 11 waterfalls are unsurprisingly the same. They're simply bundled up and expressed differently. And the undisputed evidence in this case is that exactly the same CSI results if you apply the condition 3 deductions or the condition 11 deductions. I don't think it's necessary to turn that up, but that's Mr. Faulkner's first witness statement, paragraph 47. Now, that may be a reason simply to take the condition 3 liabilities in circumstances where the condition 11 waterfall is engaged, instead of the comparable condition 11 liabilities, which would be our primary suggestion. But that would work as a matter of language. But in our submission, whichever route is taken, the right answer is not to ignore subordinated income which is in fact distributed to the Class F Noteholders. And the Chancellor was therefore, in our submission, wrong to find any support at all for his construction of the CMA in the definition of CSI.
And so the definition of CSI has to be read, you say, as if the references to condition 3 in the circumstances with which we're concerned include also a reference to the comparable parts of condition 11.
Well, my lady, that's in substance where it gets to, but the route that in our submission is the right route to get there is to look at amounts payable as identifying liabilities. And then it is quite obvious that as the interest proceeds and the principal proceeds are distributable under condition 11, there's got to be some deductions, otherwise you're not going to identify subordinated income, you're going to identify all income, and not that to the Class F Noteholders. Hence, treating amounts payable as liabilities, the liabilities identified in those paragraphs and the comparable ones identified in condition 11 is the way to deal with this further in felicity.
Right, is that a convenient point?
My Lord, it is. That's the end of
How
the
are we
third.
going? We were rather hoping to finish this today, but it makes it obviously take a bit longer. How are you doing?
My Lord, it's quite difficult to gauge how long different points will take. I'm conscious that there's some difficult points in relation to the SIT, difficult in the sense of a number of cross definitions, but I'm hoping that it won't take me more than an hour after the adjournment.
Thank you very much.
All rise.